Good morning, everyone. I am Monalisha Padhi. I am a legal intern at LEXIS and Company, and I am pursuing my BBA LLB from Bharati Vidyapeeth, New Law College, Pune, and I am currently in third year. So the topic for the today's video is right to be forgotten, and the purpose of this video is to create the awareness about this topic and why it is needed in India. So basically, what is a right to be forgotten? The right to be forgotten falls under the purview of an individual's right to privacy, which is governed by the Personal Data Protection Bill that is yet to be passed by the Parliament. In 2017, the right to privacy was declared a fundamental right by the Supreme Court in its landmark verdict. The court said at the time that the right to privacy is protected as an intrinsic part of the right of life and personal liberty under Article 21 and as a part of freedoms granted by Part 3 of the Constitution. So, what does this Personal Data Protection Bill says about? The Personal Data Protection Bill was introduced in the Lok Sabha on December 11, 2019, and it aims to set out provisions meant for the protection of the personal data of individuals. Clause 20 under Chapter 5 of this draft bill, titled Rights of Data Principle, mentions the right to be forgotten. It states that the data principle, the person to whom the data is related, shall have the right to restrict or prevent the continuing disclosure of his personal data by a data fiduciary. Therefore, broadly under the right to be forgotten, users can delink, limit, delete, or correct the disclosure of their personal information held by data fiduciaries. A data fiduciary means any person, including the state, a company, any juristic entity for an individual who alone or in injunction with others determine the purpose and means of processing of personal data. Even so, the sensitivity of the personal data and information cannot be determined independently by the person concerned, but will be overseen by the Data Protection Authority. This means that while the draft bill gives some provisions under which a data principal can seek that his data be removed, but his or her rights are subject to authorization by the adjudicating officer who works for the DPA. While assessing the data principal's request, this officer will need to examine the sensitivity of the personal data, the scale of disclosure, degree of accessibility sought to be restricted, role of the data principal in public life, and the nature of the disclosure, among other variables. So, do other countries recognize this right? The Center for Internet and Society notes that the right to be forgotten gained prominence when the matter was referred to the Court of Justice of European Union in 2014 by a Spanish court. In this case, one Mario Costeza disputed that the Google search results for his name continued to show results, leading to an auction notice of his reposed home. Gonzalez said that the fact that Google continued to show in its search result resulted to him was a breach for his privacy. Given that the matter was resolved, the center notes. In the European Union, the right to be forgotten empowers individuals to seek organization to delete their personal data. It is provided by the EU's General Data Protection Regulation law. This is a law passed by the 28 member bloc in 2018. According to EU GDPR's website, the right to be forgotten appears in recital 65 and 66 in Article 17 of the regulation, which states the data subject shall have the right to obtain from the controller the erasure of the personal data concerning him or her without undue delay, and the controller shall have the obligation to erase personal data without undue delay. In its landmark ruling, the EU's highest court ruled in 2019 that the right to be forgotten under the European law will not apply beyond the borders of EU member states. The European Court of Justice ruled in favor of the search engine giant Google, which was contesting a French regulatory authority orders to have web addresses removed from its global database. This ruling was considered an important victory for Google and laid down that the online privacy law cannot be used to regulate the internet in countries such as India, which are outside the EU. Thank you for today. That's all for the topic. Thank you, and please like and comment on the video and subscribe the channel. Thank you.